You've been meaning to get your estate plan done now for a while, maybe years. And one of the reasons why you've been putting it off is because you're afraid as to what it would cost. So let me just answer that question right now before anything else. For most Alabama families, a simple estate plan runs somewhere between $800 and $1,500. And if you're looking for a living trust to avoid probate, the costs that you're looking at are between $2,500 and $5,000. Complex situations like special needs beneficiaries or business interests or significant tax planning can cost a lot more. That's the honest range, and I will explain what drives it in either direction. I am Dee Asthana, managing partner at Southern Estate Lawyers. We help Alabama families to protect what they have built, from simple wills to complex estate plans. We do free consultations so you can get a specific number before we take any further steps. Asking how much an estate plan costs is kind of similar to asking, what does a car cost? The answer depends entirely on what you need and why. A single person in their 30s who has no children and a savings account has very different needs than a retired couple with a rental property, and business interests and grandchildren that they want to provide for in a very specific way. It's the same state, same legal process, but very different plans. Here's what pushes up the price. Multiple properties in more than one state, business interests that need succession planning, blended families with children from prior marriages, a beneficiary with special needs that needs a precisely drafted trust to ensure we protect their government benefits, and tax planning objectives for larger estates. Here's what keeps the price down: a simple asset structure. Coming to your consultation with an asset list, know your beneficiaries, what you want to give to them, and having very clear goals. The other thing I want you to know is that the cost of having an estate plan is almost always lower than not having one. Probate in Alabama can take between 12 to 18 months and consume between 3 to 7% of your total estate value. On a $400,000 estate, that's almost $28,000 gone before your beneficiaries even get anything. Let me walk you through 4 core documents in an Alabama estate plan and what each one actually does. A will directs how your assets are distributed after you die. It names a personal representative to manage your estate, and if you have minor children, that's where you can designate a guardian. Without a will, it's Alabama's intestate succession laws that decide. That's a statutory formula that the court uses with no knowledge of your family, your wishes, or your relationships. The court decides who gets to raise your children. A will does not avoid probate, it directs it. Next is a durable power of attorney. A durable financial power of attorney authorizes someone to step in your shoes and manage your financial affairs in the event that you become incapacitated. The person you appoint can then pay your bills, manage your investments, handle your real estate, and file taxes. Without one, your family would have to take the expensive route of petitioning the probate court to appoint a conservator. Not only does that process cost money, it takes months and requires ongoing court oversight. The third document is a healthcare directive. This allows a person of your choice to make medical decisions for you and gives physicians your instructions on life-sustaining treatment in the event you cannot speak for yourself. I'll tell you what I tell every client. Having a healthcare directive removes a burden from your family. Without it, your families may sometimes argue, physicians have limitations, and courts sometimes have to intervene. Next is a revocable living trust. A living trust allows you to transfer your assets into a legal entity which you control during your lifetime. And upon your death, those assets can pass on to your beneficiaries without having to go through probate, involving the courts, and maintaining your privacy. A trust is not the ideal tool for every family. If your assets are modest and your distribution goals are simple, a will-based plan may be entirely sufficient. But for families with multiple real properties, investment accounts, and a strong desire for privacy, the cost of a trust is recovered many times over in avoided probate fees and family conflict. I'm going to give you a few example scenarios. Here's Margaret. She's presently living in an assisted living facility. She has a son. Her assets include a house, a life insurance policy where she has nominated her son as the beneficiary. She also has a checking account and a car. She wants a simple plan. She wants a will, a financial power of attorney, and a healthcare directive. The cost of this plan to her is between $800 to $1,500. If she doesn't have a plan in place, the cost to appoint a guardian or a conservator for her in the event she becomes incapacitated is in the thousands. And upon her death, her son will have to probate her estate, which will also cost between 3 to 7% of the total estate value. And it takes months. Next is Thomas. He is 68 years old and he owns a home in Hoover, Alabama, and a rental property in Baldwin County. He wants his estate to be split equally between his children, but he prefers his daughter to be his financial power of attorney and also his proxy for the healthcare directive. So what does an ideal estate plan look like for Thomas? He needs a healthcare directive, he needs a financial power of attorney, he needs a will, and he needs a trust because of that rental property in Baldwin County to avoid probate. His estate plan will likely run between $2,500 to $5,000. Without it, his estate passes through Alabama probate, 12 to 18 months with court supervision, and the cost significantly more than the estate plan. Next are Doug and Carla. They own a business. They have 3 children. One of their children is special needs. They own multiple real properties in Jefferson County. They have investment accounts. Their total assets are somewhere near $2.8 million. What kind of a plan do they need? They will need business succession planning, a special needs trust for their child, a living trust for their multiple properties, and a pour-over will for each of them, financial durable powers of attorney for each of them, and healthcare directives for each of them. The cost for this kind of a plan is probably between $6,000 to $12,000, but that cost is nothing compared to not having a plan. Having this estate plan protects assets and family relationships. That is worth many multiples of that initial investment. And a poorly drafted special needs trust, one that disqualifies their child from government benefits, would cost far more than getting it right. I do want to caution you from using online services to create and execute your estate plan. These services do not allow for follow-up questions. They cannot ensure that you execute your estate plan pursuant to the formalities of Alabama law. And there is no way that they can ensure that you fund your living trust properly. We see the consequences of inadequate estate planning in our litigation practice every week. When something goes wrong, it's almost always more expensive, it was preventable, and it could be permanent. So how much does an estate plan cost in Alabama? For most families, between $800 and $1,500. And for those seeking a trust-based plan, you're looking at between $2,500 and $5,000. And more for complex situations. And this is almost always less than not having a plan at all. If you want to know what your estate plan should look like and what it will cost, just give us a call. The consultation is free and you can reach us through any of the phone numbers listed below. You can also book your consultation directly at southernestatelawyers.com. So if you are a family that needs a plan, don't wait any longer. I hope you enjoyed watching this video. Don't forget to like this video and subscribe so that you don't miss our next video.